Looks like the parties are ready. We're here in the matter of Kelchner versus CRST and others. My understanding, Mr. Wessan, you are going to have 5 minutes, is that correct, as amicus? Okay. And then the Appellee will have 15. And it's going to be Mr. von Klemperer. Thank you. And then Mr. Eckhart for the appellant. Okay. It was a little bit confusing. I wanted to confirm. All right. The clock is ready, and hold on just a minute. His clock should be 20. Sorry, we wanted to make sure, unless you want to give up 5 minutes. Okay. Thank you for correcting that. I just wanted to confirm, kind of have some wild notes here. Okay. You may begin, Mr. Eckhart. And the kids left, so you don't have to tell us where you went to high school unless you want to.
I think I have family watching, so I went to Roncalli High School, and we're the Rebels. So.
Good son. Good job, yeah.
May it please the court, my name is James Eckhart, and I represent the defendant appellant. The question before this court is whether a foreign corporation that complies with Iowa's business registration statute consents to general personal jurisdiction in Iowa, meaning it can be sued by any plaintiff on any claim, no matter how disconnected the claim is to the state. Here, for example, Mr. Kelchner is a Florida resident who traveled to Indiana to sign a contract with CRST Specialized, a company that's both headquartered and incorporated in Indiana. The court should reject plaintiff's consent by registration theory for 4 reasons. First, unlike the Pennsylvania statute in Mallory, nothing in Iowa law provides that a foreign corporation consents to general personal jurisdiction in Iowa simply by registering to do business here. And the statute that Mr. Kelchner relies on says nothing about consent or jurisdiction. Second, this court ordinarily construes statutes that purport to subject foreign corporations to personal jurisdiction strictly, and Mr. Kelchner does not deny that a strict construction of Iowa law forecloses his position. Third, this court has held that whether to extend jurisdiction over foreign corporations is a decision for the legislature, not this court to make in the first instance. And to date, the Iowa General Assembly has never held or has never passed a law providing that foreign corporations consent to general personal jurisdiction here simply by registering to do business and appointing an agent for service of process. And finally, subjecting CRST Specialized to general personal jurisdiction in this case would violate the principle that waivers of constitutional rights should be made voluntarily, knowing, and intelligently. For these reasons, CRST Specialized did not consent to general personal jurisdiction in Iowa simply by complying with the foreign corporation registration statutes. That is the view of the vast majority of state high courts that have addressed this issue and other federal courts that have addressed this issue, both before and after the Supreme Court's decision in Mallory. And that, in fact, is the rule that the U.S. Supreme Court ordinarily applies when interpreting state registration statutes. Accordingly, we ask the court to answer the certified question now.
Just one quick question about the state law, federal law aspect of this case. It was certified to us because it's a state law question, right? And the parties are apparently in agreement that we're dealing with a state law question. But your last point about the nature of consent, ordinarily when we think about federal rights and whether you've consented or waived, we usually are applying federal principles and thinking about those issues. So I guess my question is does that incorporate an aspect of federal law into our analysis, or can you help me untangle that?
So this is a question of Iowa statutory interpretation. That's why Chief Judge Williams certified the question to this court. However, in our briefing, we've raised certain statutory interpretation arguments in the context of constitutional avoidance arguments. And so it's our position that if the court adopts plaintiff's position, then that would create issues under the federal constitution, including as Justice Alito stated in his concurrence in Mallory, issues with respect to the Dormant Commerce Clause. It would also create due process concerns because, again, there is no statute that the General Assembly has passed that provides that foreign corporations consent to general personal jurisdiction in Iowa, nor is there any case from this court that has held that foreign corporations consent to general personal jurisdiction here simply by registering. And so, a conclusion that CRST Specialized has consented to general personal jurisdiction would not be, CRST simply had no fair warning or notice that that was the consequence of its decision to register to do business in Iowa.
Hey, what would the practical consequences be?
Court held in favor of the plaintiffs here.
Registration statute conferred general jurisdiction to any foreign corporation that had already registered or registered in the future.
There are currently, as we point out in our reply brief, 40,000 businesses that have registered as foreign entities in Iowa. And so if this court holds that all of those entities are subject to general personal jurisdiction in this state, any of them can be sued in Iowa for any reason. And so the Iowa courts and the Iowa citizens are going to be pretty busy litigating cases or deciding cases that really have no connection to the state of Iowa. And that's part of the practical concerns with the plaintiff's approach, Your Honor. Now,
Is willingness to register here in Iowa?
and some states like Pennsylvania have decided that they're fine with that kind of chilling effect on out-of-state businesses entering Pennsylvania's market, but ultimately, one would expect that if that's the decision the General Assembly made to subject foreign corporations to general personal jurisdiction here, it would have said so pretty expressly in the statutes, and they just have not done that here.
Lead to forum shopping, perhaps?
100%, Your Honor. And so ordinarily a plaintiff, in order to satisfy specific personal jurisdiction principles, must sue in a forum where there is some connection to the litigation. But under the plaintiff's position, because foreign corporations simply consent to general personal jurisdiction by registering here, there would not need to be any connection between Iowa and the plaintiff's claims.
The key part of your statutory argument, the lack of language discussing general jurisdiction, and I ask that because my understanding of Mallory is that the consent provision of the Pennsylvania jurisdiction statute was not the provision that was actually being litigated. It was a different subsection that just said mere incorporation shall be deemed sufficient to be subject to general jurisdiction. So is your argument here really that our statute, it's not the consent issue, it doesn't mention general jurisdiction at all, and that's kind of the defect. Is that right?
I think so, Your Honor. So our basic position, whether it's the registration statute or any other statute on the books in Iowa, nothing gives foreign corporations notice that simply by registering to do business and complying with the foreign registration statutes that they are consenting to general personal jurisdiction in Iowa. Subject to. Correct, Your Honor. Yeah.
Rely on include a provision that I think came from the Model Registration Act that says a designation in the state of a registered agent does not by itself create the basis for personal jurisdiction, and Iowa does not have that statute. How does that affect your analysis?
I don't think it changes this court's conclusion because the general presumption is, as the other state high courts that have addressed similar laws to Iowa's, which don't have that statement from the model code, is that absent an express statement from the legislature that foreign corporations will be subject to general jurisdiction in the state, the court's not going to read that consent into the statute.
DeLeon case and the KNC case, those cases specifically relied on that provision. Is that right?
So, and I think the Nevada case that we submitted as supplemental authority that may have had a similar provision as well. That's true, Your Honor, so we don't deny that those 3 states, there is an express provision in their statutes that say registration or maintaining an agent for service of process does not impact the personal jurisdiction analysis. But when you read those decisions, I think in each of those opinions from each of those state high courts, there's really a 2-level analysis. They first conclude that there's nothing in the language of the statute that expressly provides notice to defendants that they're consenting to personal jurisdiction when they register. And then they also note, and by the way, to remove any doubt, our state legislatures have expressly said this should not be used to subject foreign corporations to personal jurisdiction. And so there is textual analysis from those opinions that support our position here.
Why have our federal courts gone the other way on this question?
That's a good question, Your Honor. I think Knowlton, I don't think this court has to say that Knowlton was wrongly decided. That case was decided under Minnesota law. It didn't address Iowa law. It didn't apply the statutory interpretation principles that this court applies to cases involving interpretation of personal jurisdiction statutes. So I think that's, if the court doesn't want to say that Knowlton is wrongly decided, you can just distinguish it on that basis. But I think our position, as outlined in our briefs, is that Knowlton was wrongly decided. It's inconsistent with U.S. Supreme Court decisions going back 100 years, the same decisions that were decided right after the Supreme Court decided the Pennsylvania fire case, which is a decision that the plaintiff and the Solicitor General rely on heavily. And I think in terms of the federal district court decisions in Iowa that have reached the opposite interpretation that we're advocating for here, I think that's best explained just by the fact that those district court judges are bound by the Eighth Circuit's decision in Knowlton. And I think Chief Judge Williams made it clear in his certification order and in his order denying our motion to dismiss in the federal litigation that perhaps a better rule would be the one that we're advocating for before the court here, but his hands were tied by the Eighth Circuit's decision in Knowlton and subsequent cases, and so he felt he could not deviate from that precedent.
If I understand Mr. Kelchner's argument correctly, I think the position, and I'm sure they'll correct me if I'm misstating it, is in interpreting the statute at issue 617.3 indicates that the legislature uses the term service of process as a substitute for jurisdiction, and that we should kind of interpret and synthesize all of those together. And if you do that, then there's consent to jurisdiction. What is your response to that?
I think their reliance, and that's Iowa's long-arm statute, Your Honor. I think their reliance on the long-arm statute actually backfires. And I think the point that Mr. Kelchner makes is the long-arm statute doesn't use the phrase or doesn't use the word jurisdiction, but it's always been construed as a jurisdictional statute. That's their basic point on the long-arm statute. But I don't think that captures the whole story. I think in cases where this court has applied the long-arm statute, it's always engaged in a 2-step analysis. The first step has been whether the plaintiff complied with the terms of the long-arm statute and identified a basis for serving the defendant under the long-arm statute. But the second step has always been whether the exercise, even if the plaintiff has complied with the statute, whether the exercise of due process or whether the exercise of personal jurisdiction would comport with due process, including the minimum contacts analysis under international shoe. And so just to take plaintiff's analogy to the long-arm statute and apply it to the registration statute, they want to forego that secondary analysis. Plaintiff's position is so long as our agent is served, our registered agent is served with process, that's enough for jurisdiction. There's no need to engage in any minimum contacts or other.
Looking at 617.3, the long-arm statute, sub 2, that if registering to do business in Iowa meant you consented to general jurisdiction, then a lot of this language would be totally superfluous, because then if you're a foreign corporation, you committed a tort in Iowa, well, you don't need to be appointing your registered agent for purposes of service. I mean, in fact, you'd be subject whether you committed the tort or not. The statute kind of doesn't really make sense. You don't need a long arm almost, if they're correct that registering, at least as to someone that's a company that's registered in Iowa. Am I missing the point there?
I agree with that analysis, and our basic position is pretty simple. It's if the Iowa legislature wanted to subject foreign corporations to general personal jurisdiction simply by reason of their registration or appointing an agent for process, it would have said that. It didn't say that, and so the plaintiff still needs to demonstrate some alternative basis for jurisdiction, whether that's specific personal jurisdiction under the long-arm statute, or perhaps consent through a form selection clause, which are really the only cases from this court where it has held a defendant consented to personal jurisdiction. Unless the court has any other questions, I'm happy to rest.
On 20, you took 15. Okay, thank you. Klemperer.
Good afternoon, Madam Chief Justice, and may it please the court. My name is Mike von Klemperer, and I represent the plaintiff Appellee. With me at counsel table is my co-counsel, Brian Marty, and the Solicitor General, Eric Wessan. This case...
High school.
Bronxville High School, Bronxville, New York.
Dave, he gave his for his mom and dad. Thank you very much.
This case started when the plaintiff served the registered agent for CRST Specialized and its corporate sisters, CRST Expedited and Lincoln Sales, in Des Moines, a few blocks from this courthouse. In this certified question, Appellee seeks to reaffirm a bedrock principle of American jurisprudence, that in-state service establishes a court's personal jurisdiction over the person. Specialized is part of a closely integrated
Principle. I mean, even Mallory is kind of, kind of an unusual U.S. Supreme Court decision, right? It's 5-4, but then one of the five says, well, I think the wrong constitutional argument was raised, and I might be with the other four if they raise the correct argument. Is that right?
come out of nowhere, Your Honor. So Mallory simply was determined that Pennsylvania Fire, which was a Supreme Court decision from 1917, had already resolved that question. And every time the due process question has come to the U.S. Supreme Court, it has consistently resolved that in favor of finding consent jurisdiction through registration.
What do we make of Morris, and I'm not coming up with the other case that came kind of in that same era, case after the Pennsylvania Fire case?
Sure. So the appellant makes the argument that Morris and the Missouri Pacific Railroad case essentially established a rule of statutory interpretation against interpreting state law as consent by registration. It's important to look at the actual facts of those cases, though. In Morris, there was the Mississippi registration statute expressly limited the registration to actions growing out of conduct in Mississippi. And in the Missouri Pacific Railroad case, there was already an authoritative interpretation of Louisiana law by the Louisiana Appellate Court. And what the Supreme Court held in both of those cases is we will follow the authoritative construction of state law as provided by the state appellate courts and the state legislatures. It did not establish a rule that every state must follow in interpreting their own laws. And it's also important to note that in Mallory, which is a case that addressed this exact issue, none of the various opinions cited from Morris or Missouri Pacific Railroad. So if those cases had in fact established this rule, you would have expected the justices in Mallory to discuss it, but none of them did.
Case have to do with Iowa. you've got a Florida plaintiff and Indiana defendants.
CRST Specialized is part of a closely integrated Iowa-based family of corporations.
Making allegations to pierce the corporate veil, to impute the parents' contacts with Iowa to the defendant parties or any other way? Or I mean, aren't you asking us to disregard corporate formalities?
The corporate contacts are relevant, I think, for two purposes. One, we have a minimum contacts argument as well that's before the district court that hasn't been certified. So clearly that's relevant. I think the relationship of the companies to Iowa is also relevant to dispel this notion that if the court holds in the appellee's favor, there's going to be this flood of case law unrelated to Iowa. This case has deep Iowa roots. The corporations are all based in here. They share, there's a single corporate board that.
I assume this is in federal court. Is it in federal court because of CAFA? Is that right? Is that why you're there? And then are you seeking to represent a class, a nationwide class? Would it include Iowa residents in this class?
This is a class action, and we are asserting jurisdiction is based on CAFA. It's also based on diversity because we are suing under an Iowa statute.
I appreciate your discussion of the Iowa roots on this case, but I have a hard time seeing how we could write an answer to the question from the federal court that would limit it to Iowa cases, to Iowa-bound cases, right? I mean, because we do have, I forget what the number, thousands of foreign corporations, many of which don't have those kinds of Iowa ties. And if we answer this question that our statute effectively has said that all those corporations consent to general jurisdiction here, then I do think the floodgates are opened. And so I'd like to hear your answer.
I don't know that you can answer the question by limiting the cases just to Iowa-based contacts. I don't think that's necessary. I think the concern about the floodgates opening is unfounded and unsupported by any evidence. If that were the case, you would expect the same thing to have happened in Pennsylvania in the wake of Mallory. There are other states, Minnesota, Florida, and another state that also has recognized consent through registration, and we don't see the floodgates being open in those states. So I appreciate the policy concern, and if that was a concern for the legislature, they could certainly amend the statute.
Those states then are open to lawsuits that just involve citizens of other states and involve lawsuits that have nothing to do with the forum state. Is that fair?
But the same could be said for a domestic corporation, which is subject to general jurisdiction and can be sued on any claim, whether or not the claim arises in Iowa or not.
It's a little different, right? Because at least then you have a corporation that's based in Iowa, so presumably there's at least some connection to Iowa. I mean, I think Justice May's point is well taken, which is you could have parties not from Iowa who are expending resources from Iowa judicial branch and Iowa jurors in resolving cases that just have no Iowa connection at all.
Well, I think it's important to keep in mind that not every corporation that wishes to do business in Iowa needs to register as a foreign corporation. It's only those corporations that wish to establish a long-standing and continuous business relationship with Iowa, and they must do so by registering with the Secretary of State. They need to file formal paperwork. The paperwork is not a mere ministerial task. In fact, it needs to be signed by the chairman of the board for that corporation or the board, a senior officer. And they must appoint a registered agent in this state whose one and only job is to receive service of process. And that same registration statute applies to both domestic and foreign corporations.
Code-based kind of textual argument here.
I think there's a lot of Iowa authority finding jurisdiction over foreign corporations through in-state service of process, and I'd be happy to discuss that. If we're looking strictly at the code, as another justice mentioned during the previous argument, the Iowa long-arm statute, it doesn't use the word jurisdiction, but it's clearly a jurisdictional statute, and if a foreign corporation commits a tort in Iowa against an Iowa resident, this will be, quote, deemed doing business in Iowa by such foreign corporation for the purpose of service of process or other original notice on such foreign corporation. The Iowa Business Corporations Act as well uses the term service of process consistently to mean.
It's on to say, and if the corporation doesn't have a registered agent, shall be deemed to constitute the appointment of the Secretary of the State. Well, you wouldn't need I mean, this implies that you have to, that even if you have a registered agent, you're not, they can't serve you unless you actually committed a tort in Iowa and subject you to jurisdiction. Some of that language would clearly be unnecessary, wouldn't it?
The long-arm statutes were adopted by many states in the wake of International Shoe, which expanded state court jurisdiction over foreign corporations who had not consented to jurisdiction there. And so if those foreign corporations had committed a tort in a state, the states needed a way to exert jurisdiction over them. And so where you have an unregistered foreign corporation, the long-arm statute gives the state the means of asserting that jurisdiction.
Corporation does not have a registered agent or agents would be unnecessary if registering to do business subjects you to general jurisdiction, because you wouldn't need that. You'd already be subject to jurisdiction. You wouldn't need the authority under 617.3 to serve that corporation in Iowa, right?
It would become superfluous, and I believe at the end of the long-arm statute, it says that this should not be interpreted to restrict other methods of securing jurisdiction, including traditional methods such as in-state service of process.
Where did the statutory violation or tort in this case that you're suing over take place for your named plaintiff?
We are suing under the Business Opportunity Promotions Act, which protects individuals who are offered business opportunities. There needs to be certain disclosures, and there can't be misleading statements in the advertisement for those business opportunities. The underlying conduct is largely centered in Iowa because the corporation, the corporate family is essentially at home in Iowa. The Specialized is not registered here, but the corporate family is here. The board of directors is here. And they share many corporate functions, including the recruiting function, which are the people who are putting out the advertisements. And much of that work is done in Iowa.
If misled, was he in Florida or Indiana or?
He was in Florida at the time.
Or set foot in Iowa before the lawsuit was filed?
Not to my knowledge.
And where the disclosures that you allegedly relied on, those were from Indiana corporation?
So the BOPA statute requires disclosures. Those disclosures were not made. And on the contrary, there were advertisements with misleading promises on what he could expect to earn. Those advertisements
Run by the named defendants, which are Indiana corporations, right?
all three of the defendants collectively.
Those defendants headquartered in incorporated.
Every defendant in this case is incorporated in Iowa except for this one corporation, including the parent company CRST International, which was recently added as a defendant in the court below.
In Indianapolis or Indiana.
What was going on there? I'm not following.
I thought that these defendants were doing business and were based in Indiana, where he went to visit for this. Am I getting that wrong?
Corporate defendants, CRST Specialized, is based in Indiana. The rest of the corporate family is based in Iowa.
Of the relationships between the corporate entities relevant to the certified question that we're answering?
I think that they're relevant in rebutting these public policy arguments that the appellant advances, that if you are to answer this certified question in the affirmative, there's going to be a flood of litigation that's completely divorced and irrelevant to Iowa. To discuss some of the relevant precedent from this court, in Fisher versus Keller, this court held that it is a basic and universal rule that there are only two ways to acquire personal jurisdiction. One, by service of process on the defendant, and two, by the defendant's voluntary appearance. Over the last 100 years, this court has held time and again that in-state service of process on a foreign corporation's registered agent or general agent constituted established personal jurisdiction over that defendant. So in Kalbach versus Service Station Equipment Company, the court held that service on an Iowa corporation's in-state registered agent established personal jurisdiction. It also noted that the legislature would not, quote, give greater advantage to a corporation in the way of evading service in actions than it gave to natural persons. In other words, presence in the state was sufficient, and for a corporation, presence is manifest by designating an agent who can receive process here.
It seems like a lot of the cases you're citing, I mean, they say that, but the facts, at least as I understand them, are corporate entities that actually have substantial business operations in the state of Iowa. I think Justice Barrett, in her opinion, and Mallory kind of makes that same distinction, that we do have these cases, but they've always, like, in effect, been more like substantial contact type cases. And that seems to be what Justice Alito also says in his separate opinion, where he says the only question here is whether the 14th Amendment permits a large out-of-state corporation with substantial operations in a state complies with the registration statute. So it seems like there still has to be, right or wrong, some sort of substantial presence of that particular business's operations in the state to allow jurisdiction to attach.
As I say, I'm out of time. Permission to. Your Honor, I think it's important to keep in mind the context of those cases. Most of these cases were from the beginning of the 20th century, before international shoe had even been decided. And it's not as if those cases are making a minimum contacts assessment and then deciding, oh, and there's a registered agent here, so there's jurisdiction. Rather, it's the presence of the agent to be served in the state that is the deciding factor in each of those cases.
Maybe, but it seems like international shoe in the later cases synthesized that existing body of case law and said this seems to be the general rule, which is when a business has substantial contacts with the state and then you serve somebody, that's sufficient to satisfy due process concerns. I mean, I understand what you're saying, that they predate international shoe, but it seems like that's the case law on which international shoe builds, from my point of view.
To that in Mallory, there's a discussion of international shoe. It made very clear that international shoe expanded state court jurisdiction. It did not displace traditional means of securing personal jurisdiction. Thank you.
Excuse me, Mr. Wessan?
May it please the court, counsel, Eric Wessan, Staples High School, class of 2010, go Wreckers, Westport, Connecticut. I've got 5 minutes. I think I'm going to try to touch on our main affirmative point and then address a bunch of the questions that you all have asked. But of course, if you have more questions for me, I'm ready. So first, I think there's a bit of a category error in how to think about personal jurisdiction in this case. So many of this court's recent cases have dealt with the comparison of general and specific jurisdiction. And that makes sense. That's what recent U.S. Supreme Court cases have done too, especially post-Daimler. And in fact, I think if this case was before this court 5 years ago, it would be a much more difficult case for the side that we're arguing. But what's really important is that beyond general and specific jurisdiction, there's also the idea of jurisdiction by consent or waiver. There are other ways that personal jurisdiction can be present. For example, in this case, in the federal district court in the Northern District of Iowa, if the defendant had not raised the personal jurisdiction defense until summary judgment or trial, it likely would have been found to be waived, regardless of what the underlying circumstances of the case were. What Pennsylvania Fire said is that a company choosing to register an agent in a state, establishing a continuous presence in that state, is sufficient to show consent to receive process in that state. And that's why, unlike, as Justice Oxley, you mentioned, our statute does not disclaim personal jurisdiction by consent. It's silent on the matter. At the time at which the original statute was enacted in Iowa, that was the traditional common law way of allowing a foreign corporation to be subject to personal jurisdiction in a state. Our statute followed that tradition. That tradition was embraced by this court in Utrecht, which followed 1 year after Pennsylvania Fire. Of course, there was quite a bit of time between those early 20th century cases and Mallory, but what Mallory said in the part of the opinion that all 5 justices joined, Part 3B, first sentence, Pennsylvania Fire controls this case. And our statute in Iowa is very similar to the Missouri statute.
It seems like the distinction to me is, I understand your point about category error. This is really a question of statutory interpretation and whether our statute actually relates to general jurisdiction, right? And the Pennsylvania statute's very clear, like, under these 3 circumstances, that shall be deemed sufficient to establish general jurisdiction. And our statute doesn't have any general jurisdiction language.
3 responses to that, Your Honor. First, Part 3B references Pennsylvania Fire in the first sentence. That related to a Missouri statute that was contemporary of Iowa's statute at the time. And that Missouri statute has similar language to Iowa's and does not include the specific language that Pennsylvania's has. But then I'd urge you to look again in 3B, part of the opinion that has all 5 justices, at footnote 5. Because there was a question, because the Pennsylvania statute doesn't have the word consent, and whether there was a magic words requirement that required the word consent for Pennsylvania's statute, which is admittedly different from ours, to be enough to establish the traditional consent jurisdiction in Pennsylvania. And what the Supreme Court said was, you don't need that word. There's not a magic words requirement. Here, we lack a couple of the words that the Pennsylvania statute has. But our statute is materially the same as Missouri's, which is materially the same as well with Minnesota's and with South Dakota's, which were.
To, we're not bound by the Eighth Circuit, right? And we're not, and this was sent to us because it's presumably an issue of state law. We get to interpret our own statute and what we think the words in that statute mean. And I don't see the word general jurisdiction, the word consent, the word waiver, any of that stuff, right?
Everything you just said, the last paragraph of Section 3B in Mallory talks about the Pennsylvania Supreme Court getting out ahead of its skis and finding that Pennsylvania Fire was no longer binding on the states. So there's no obligation for this court to follow those Eighth Circuit decisions, nor the Northern District of Iowa decisions interpreting the same statute, but it would be a departure from what is the existing status quo in our federal courts. And this court, of course, has the ability, obligation to interpret the law.
I mean, the question in Mallory isn't what did the state statute say, it's whether or not the state could constitutionally exercise jurisdiction. The threshold question in this case isn't the permissible scope of the state's power, it's whether or not this statute actually invokes general jurisdiction. And that's a pure state law question that, depending on how we answer it, that may implicate Mallory, that may implicate 14th Amendment issues. Justice Alito may think it implicates the Dormant Commerce Clause. But until we get there, it's just a pure state law question of statutory interpretation.
Your Honor?
Yes.
That is my second fallback argument. If this court is going to rule against the plaintiff, Appellee here, then we respectfully request you do so solely on state law grounds, so that if the legislature wants to add the magic words that are present in the Pennsylvania statute, it may do so. That said, the straightforward way to approach this law, and I take everything that you've said, Justice Mansfield, about the language of the statute, but part of the issue is likely that when the statute was enacted, which goes back more than 150 years, it was using a language at the time that was understood to be a consent waiver of personal jurisdiction. That's what the Missouri fire case said. The Pennsylvania fire case, which was a Missouri case, said. If you look at pages 95 to 96 in the Federal Reporter of that decision, then you'll see that the Supreme Court, was Justice Holmes in his clear writing says, look, if a corporation wanted to consent to service in a suit, it could absolutely do so. Because personal jurisdiction is not subject matter jurisdiction, it can be waived.
Permission, I actually want to follow up on one other thing. In your as customarily well-written amicus brief, you start off, like in the second paragraph, with this statement. This case threatens Iowa's sovereign authority to regulate interstate commerce and protect its citizens from deceptive business practices. That's not really the case here, is it? We're not talking about protecting Iowans from deceptive business practices, are we?
The statute at issue here is an Iowa statute, and the class is a nationwide class that could and probably would include Iowans. And the reason the state appeared as an amicus here today is because our understanding of the status quo, which is the way the law is interpreted by the Northern District of Iowa, which is consistent with Knowlton and Sondergaard, which itself is consistent with Mallory and Pennsylvania Fire, we believe that that status quo should continue. And to the extent that there are concerns about chill, as Justice Wanderman referenced, that chill hasn't happened since 2011, when the Northern District of Iowa, for the first time, said that our statute had this result. And if it does happen, because it's a purely statutory issue, the legislature can change the current status quo. Because this court has not yet had the opportunity to weigh in on this important legal issue, the only case law on it is the Northern District of Iowa, and that's been the law in Iowa for 15 years now. And there hasn't been an opening of the floodgates.
Still could protect Iowans if the class were just solely Iowans, right? Like if you found an Iowa plaintiff instead of a Florida plaintiff, and then you had the long arm statute, so the tort would have been, I guess, committed in Iowa against Iowans. I mean, the state's interest with respect to protecting Iowans still could be vindicated, or am I missing something on that?
Back to a question Justice Mansfield asked earlier too, which is, what about this Secretary of State 617.3? You'll note in our brief, we don't reference 617.3 because I think it's a little bit of a distraction. Yes, there could be an Iowa-based class, but if you, as this court has long held, foreign corporations have no right to do business in the state of Iowa at all. And if the state wants to allow foreign corporations to do business here, it's allowed to enact rules. Some of those are in 490, 102, and 103. And basically, what the state did when it enacted those laws 100+ years ago was say you've got to have an agent in our state to receive process. If they didn't do that, and the default agent is the Secretary of State, I actually don't think the consent section would be met. And I think that would be one way to read it, not to be superfluous with 617.3, but for example, if CRST Specialized did not have a registered agent in the state of Iowa.
Entirely superfluous. One more question. Is TikTok registered to, any of the TikTok entities registered to do business in Iowa?
Yes, Your Honor. There are many entities that are registered.
Spend all that time in that other argument in Iowa City last month.
Your Honor, the answer is that I became familiar with Section 490 after briefing was complete in that case, and I believe that we do reference 617.3 in our reply brief, and that if this court were to rule that jurisdiction by consent is appropriate, then regardless of the outcome of the fully briefed issues in that case, which deal with specific personal jurisdiction, and which of course I believe the state has clearly cleared the bar, there's reasons why it is important to protect both specific personal jurisdiction and jurisdiction by consent, which has been recognized in this state for more than 100 years. But yes, In theory, that would be another mechanism to show personal jurisdiction is available against TikTok. I'm well over time, if there are no further questions. Thank you.
Mr. Eckhart, good luck addressing cases that we heard in Iowa City when you were probably in Indiana.
I listened to that argument with interest, Your Honor. I'll start with the Solicitor General's statement that his fallback position would be for this court to simply hold that as a matter of Iowa state law, CRST Specialized and the 40,000 other out-of-state registered businesses have not consented to general personal jurisdiction under Iowa law. We're completely happy with that result and would be fine with that. I'd also like to address the court's discussion of Pennsylvania Fire. And so there are two relevant decisions 100 years ago in the Pennsylvania Fire case. There's the Missouri Supreme Court's decision, and then there's the U.S. Supreme Court's decision in that case. The Missouri Supreme Court decision was a statutory interpretation, and it also addressed the Due Process Clause under the federal Constitution. The U.S. Supreme Court decision in that case took as a given Missouri Supreme Court's interpretation of its statute and only determined whether or not the exercise of personal jurisdiction was consistent with due process. Now, the Missouri Supreme Court decision in Pennsylvania Fire was overturned by that same court 11 years later. And this history is explained in the Missouri Supreme Court's decision in Dolan from 2017. It lays out this history, and we cite that in both our opening paper and in our reply brief. Now, Dolan, the Missouri Supreme Court in 2017, interpreted Missouri's current registration statute, which is almost identical to Iowa's, and it rejected the arguments that both the plaintiff and the Solicitor General are making here about Missouri's current Supreme Court or current registration statute. So to the extent this court is looking for guidance.
Saying the current Missouri's registration statute, has that changed? Is it not the same as it was in Pennsylvania Fire?
Has changed, and
But our statute is still the original statute from...
Honor, so it has changed. So I think the current statute in Iowa dates back to 1989, and it uses language identical. It probably came from the same model registration act, Your Honor. But to the extent this court is looking for persuasive authority from Missouri Supreme Court in guiding its opinion, the relevant source is the Dolan decision, which construed almost identical statutory language under Missouri law.
I'd like to clarify my understanding of where these parties are located. And CRST Specialized Transportation, Inc., is that an Indiana corporation headquartered in Indiana?
Yes.
And that's the corporation that the plaintiff contracted with, the named plaintiff? Yes. Yeah, okay. And then to the extent, are any of the other named defendants Iowa corporations? Yes. So wouldn't those defendants be subject to general jurisdiction under Daimler? So really our only issue, the practical effect is only as to the non-Iowa, the non-resident CRST Specialized. Okay.
CRST Specialized is the only defendant that objected to personal jurisdiction in the federal court, and that's still the only defendant that's objecting to personal jurisdiction before this court. On the question of the fact that this is a class action and may encompass Iowa residents who are unnamed class members, the U.S. Supreme Court case law is clear that you only look to the context between the named plaintiff and the defendant when assessing whether personal jurisdiction is present.
Maybe we're getting ahead of the merits here, but the Iowa Business Opportunity Promotions Act, does that have a provision that states it applies outside of Iowa borders, extraterritorially?
It does not say that, Your Honor. There are statutory provisions of the statute that define its scope. The parties do dispute whether the statute even applies in this case. It's all of the defendant's position that because the relevant conduct happened in Indiana, that the statute, the BOPA statute, doesn't even apply, and Mr. Kelchner has no standing to assert claims under it. But that really is a separate issue from the personal jurisdiction question, and Going back to Pennsylvania Fire real quick, Your Honor, though. The three cases, Missouri Pacific and Morrison Co., and there's a third case which was not cited in the briefing, but is discussed, or at least cited in Mallory and by those two other cases, Robert Mitchell Furniture. So that adopts the same statutory interpretation principle, which is that absent express language in a state's registration statute, courts should not construe the statute as consent to jurisdiction. I see my time's up, Your Honor, unless there are any other questions.
Thank you. The certified question presented to our court in the matter of Kelchner versus CRST is hereby submitted, and court is adjourned for today. Thank you.